Welcome to Antitrust Code by Concurrence. Concurrence is the leading antitrust database with over 30,000 articles on competition law. Concurence is also the largest network of antitrust experts with lawyers, economists, enforcers, and academics in 85 countries. By listening to this podcast, you will learn the fundamentals of competition law and hear about the latest antitrust news thanks to our guests, the best experts in the antitrust world.
Welcome to our podcast on private enforcement of antitrust claims. I'm Joeri Klein, General Counsel for Deminor in the Netherlands, and we are broadcasting from our headquarters here in Brussels. Deminor is a litigation funder, and we fund all kinds of litigation, including these private enforcement of antitrust claims. It's one of our core businesses. We do that generally against no cure, no pay, no risk arrangements. Although alternative arrangements are possible as well. I'm here today with two colleagues. On my right, Giacomo, please introduce yourself.
Hi, Joeri. Thank you. As you anticipated, my name is Giacomo Lorenzo, and I'm working at Deminor as a senior legal counsel. Before joining Deminor, I worked as lawyer in an Italian international law firm, and I completed an LLM at University of Lausanne with a specialization in international business disputes.
On my left, I have Felix.
Hello, my name is Felix. I am very happy to be here today and talk about antitrust actions in Germany. I'm General Counsel for Germany, Austria, and Switzerland. I'm with Deminor since 2016 and was working as a lawyer before, involved in all kinds of commercial disputes, including antitrust actions.
Yeah, and it's not a coincidence. I'm sitting here as a representative for the Netherlands, and on my right, Italy, and on my left, Germany. Those are three jurisdictions where we have seen a lot of private enforcement actions related to antitrust infringements. And what we want to do today is to zoom in on these three jurisdictions to see what are relevant differences or what are maybe things that make these jurisdictions stand out as a jurisdiction for those kinds of litigations. Things where we will look at is whether it's possible, for example, to claim damages collectively. What is the role of funders and what are advantages to work with a funder in these jurisdictions? What about adverse party costs, access to evidence, and various other topics. But as a starter, I think it is good to have a look at what are the possibilities in these three jurisdictions when it comes to collectively claiming damages. I will first start with you, Felix. If you look at Germany, what are the opportunities in Germany to claim damages? Can you do that collectively? And if so, how is that structured?
It's a bit complex in Germany currently. There's no US-style opt-out class action mechanism. Instead, victims of a cartel have to opt into litigation. Today, the most used structure to do that is to bundle claims in a group action or to use the assignment of claims model. The bundling of claims in one group action is well established in Germany. Deminor has used it in Germany many times, but under certain conditions it can be difficult to manage a group with hundreds or even thousands of plaintiffs. Therefore, clever lawyers came up with the assignment of claims model, and in that case victims of a cartel assign their claims to an SPV, which then serves as plaintiff in court. The advantage is evident. You don't have hundreds of plaintiffs, but just one plaintiff. But there are also some downsides to the structure, as for example, there's a potential conflict between the SPV and the claim holders, or the claim holders with weaker or stronger claims. The validity of the assignment model was long disputed, especially the lower courts in Germany considered that it violates the Legal Services Act, and therefore the assignment is void, and therefore the wrong plaintiff, the SPV, issued proceedings. In its Lex Fox and Air Berlin decision, the Federal Court of Justice found that the assignment model was valid, in line with the Legal Services Act. The court found that any potential conflict of interest within the structure is offset by efficiency gains, and most experts believe that the discussion about the validity of the assignment model would end there. To probably everyone's surprise, the lower court of Stuttgart last year rendered a decision and saying that the assignment model in that case would be invalid because it is based on, or it is in the context of antitrust law, which is especially difficult. We do not believe that this argument will hold before the Federal Court of Justice, but plaintiffs should be careful and assess the situation very, very precisely before choosing the assignment model today in Germany.
Yeah, so you have opt-in mechanisms available. SPV model is approved but still challenged. The bundling of claims, having multiple named plaintiffs appearing in the proceedings, that's fully accepted and not an issue in Germany, right?
That's it, exactly.
Yeah. Very interesting. And when we look at Italy, Giacomo, how are things structured there? Can you do opt-in litigation, opt-out, collective, individual?
Yes, so generally speaking, group actions are permitted under the Italian law. Mm-hmm. And in Italy, before we had this special legislation on the class action proceedings provided by Article 140 bis of the Consumer Code. But after, in 2019, this special legislation has been amended by the class action reform. Mm-hmm. And basically, with the class action reform, the discipline of the class action has been moved from the Consumer Code to the Italian Code of Civil Procedure. And there are very innovative, new feature of the class action. Probably the most important innovation is that right now the class action is available also for companies and for professional. Before was a procedural instrument available only for consumer and user. And of course this has an important impact, in my opinion, also on the antitrust class action. Another innovation is, as you correctly said, that we have an opt-in system, but it is possible to join the class action not only after the publication of the order ruling on the admissibility of the class action, but also after the publication of the decision. Mm-hmm. Ruling on the case and the establishment of the liability of the respondent. And lastly, I think that what is very interesting also from litigation funder perspective is the reward fee, because the unsuccessful respondent is obliged to pay reward fee to the representative of the class and to the plaintiff's lawyer. And this is calculated as a percentage of the compensation due to the members of the class. However, I have to say that the new reform of the class action entered into force in 2021, mm-hmm. And it is available only for the class action for a violation occurred after 19 May 2021. So mm-hmm. It's still a new tool, and probably is not the most common way to start a group action. As you correctly said, for Germany, I think that in Italy is the same. The most common way is to bundle individual claim in one ordinary civil proceedings. But probably in the future it will change, and the class action will be more used.
Very interesting. So some very interesting developments, and for these class actions, we will definitely have to see how these will pan out in the Italian context. But indeed, so the bundling of claims, the old opt-in model is still the most used one due to the temporal limitations of this class action act.
Yes.
Then moving to the Netherlands, is it possible to collectively claim damages? The answer is yes, definitely. The Netherlands, first of all, has the opt-in mechanism. This is the bundling of claims, similar to Germany. So it's accumulation of claims with multiple plaintiffs appearing in one and the same proceedings. You can also make use of an SPV that is contractually mandated to act on behalf of the litigants, so such an SPV, for example, a foundation, files the claim on its own name, but for the benefit of the plaintiffs behind it, that contractually mandated this SPV. But a very special feature of the Netherlands is that we also have an opt-out mechanism for litigation. That is the Dutch WAMKA. This makes it possible to file an opt-out claim for damages. So you have one foundation that acts on behalf of a class. And basically, if you are a Dutch claimant, you are bound by what this foundation achieved through this litigation unless you opt out. So it's basically the opposite model. We have, however, not seen many antitrust follow-on claims under the WAMKA. And the reason for that is a bit similar to Italy. It's rather new. It was enacted in 1 January 2020. And yeah, there is also a temporal scope. It has to be about events after 2016. So it's rather new and young, but I think these opt-out actions in the Netherlands will be tested and used in the near future. So it's rather clear from these answers that when it comes to the structure of the claim, there are similarities between Italy, Germany, and the Netherlands when it comes to the opt-in model. And I think in all three jurisdictions, we're looking at new possibilities and developments for the near future. But it's certain that these still will have to be tested. And we will have to see if they can really be efficient mechanisms for such actions. Then maybe good, because we already discussed a bit about opt-in litigation being tested. Let's have a look at important judgments and settlements or pending cases in these respective jurisdictions. Giacomo, Italy, what is happening there? What has happened there that is relevant in this field?
Yes, I think that in Italy there are several important cases when you look at the antitrust field. However, probably the most important case, also with respect to the private enforcement, is the corrugated cardboard cartel. We are currently working on this case, and basically in 2019 the Italian Competition Authority established the existence of two anti-competitive agreements between the main producer of corrugated sheet and packaging, and after the decision was appealed before the administrative court by the members of the cartel, with an exception for the leniency applicant, but the TAR rejected most of the appeals, and now the proceedings is pending before the Consiglio di Stato, that is the higher administrative court. Mm-hmm. And it is interesting because in November we received the first decision from the Consiglio di Stato that confirmed the existence of the cartel. Okay. So now all the victims of the cartel can, start the civil proceedings asking for the compensation for the overcharge that has been applied. And probably this is the most important cartel that was found in Italy. There are other, like the International TV Rights Cartel. Mm-hmm. The seventh cartel is also, an interesting case in Italy, but I would say that the most important right now is the corrugated cardboard cartel.
Okay, very interesting. And that's being structured under the old or under the new regime?
No, as I said before, currently there are no class action pending in Italy with regard to the antitrust mm-hmm. matter. So I think that the group action are structured as ordinary proceedings with several plaintiffs. Okay. And I think that all are acting in this way, and we are doing the same. Yes.
Okay, thank you. And Felix, Germany, can you say something about important cases and settlements?
Well, there have been several important decisions by the Federal Court of Justice, so the highest German civil court. Those decisions have mostly been plaintiff-friendly. Examples are, for example, the trucks cartel, the air freight cartel, and the rail trucks cartel. Experts now believe that the, biggest challenges and biggest legal questions have been cleared up by the Federal Court of Justice. One rather interesting recent development is that the Federal Court of Justice emphasized the role of judges to estimate damages, so as to assess them freer without using a court-appointed expert. The lower court of Dortmund followed this decision and estimated the damages in a private enforcement action. If this will hold in appeal, we do not know today. Otherwise, a higher regional court of Celle also followed this decision and assessed or freely assessed damages.
That's an interesting development. So things are becoming more concrete in Germany, I would say, when it comes to these kind of actions.
Definitely. It was a black box for quite a while now.
Mm-hmm.
But this is, especially this plaintiff-friendly judgments, make Germany a very attractive jurisdiction now to enforce private damage claims against cartelists.
Very interesting. Well, I see some parallels with the Netherlands. We also have an air cargo litigation ongoing. Started in 2010, still pending. Elevator cartel, still pending case from 2010. We've seen two important settlements in the cartel area. It's the paraffin wax cartel and sodium chlorate, both settled in the Netherlands. And one very active ongoing case, that's the trucks cartel. I think even in Italy, there's litigation on that. In Germany, the UK, and in the Netherlands as well. There are 4 waves of grouped actions in the Netherlands, and we are involved in the first wave and the fourth wave. On behalf of a large amount of clients. Important case, groundbreaking in various aspects, and we'll get to that a little bit later when we will discuss the general attitude of the courts in these jurisdictions. But before we get to that, important question on adverse party costs. That's of course a relevant factor when you start litigation. It can be, in some jurisdictions, very costly. In other jurisdictions, still costly, but maybe less costly. For the Netherlands, I can say that the adverse party risk is relatively low. Relatively, it can still be substantial because you generally litigate against various defendants. So not one, but maybe 8 or 10. And even relatively small amounts can then still add up. But compared to other jurisdictions in the Netherlands, it's rather cheap. But it's interesting to see how that will work in Italy, for example. Is the risk high in Italy for adverse parties or generally low, or how would you perceive it?
So broadly speaking, in Italy, the cost follow the outcome of the proceedings.
Mm-hmm.
So under Article 91 of the Italian Code of Civil Procedure, with the final decision, with the final judgment, the judge ordered the losing party to refund the legal cost to the counterparty. So the losing party will pay for the cost also of the counterparty.
Mm-hmm.
However, there are some cases in which the judge can order the compensation of the costs. So when both the parties have partially lost, for example,
mm-hmm.
or when the legal matter was really complicated or was a new legal matter. So in this case, the judge can compensate the cost among the parties. Regarding the how expensive are the legal costs in Italy,
mm-hmm.
Probably is not the most expensive jurisdiction from this point of view, but with regard to the private enforcement proceedings, we know that you have a huge cost for the expert, because you need experts that are highly specialized in this particular field, and also the lawyer. Usually the lawyer that we as Deminor appoint are highly specialized in the private enforcement, and so the cost can increase, of course.
Yeah, so that's mainly your own costs, of course.
Yes, my own cost.
Do you pay the expert cost of the other party as well if you would lose the litigation?
If you lose the litigation, of course, you have to pay, as I said before, the cost of the counterparty. And in this case, the judge will rely on the ministerial rates, that are set and probably will be lower than other jurisdiction, like for example in Germany, and also the taxes, like contributo unificato, for example,
mm-hmm.
is not very high. So the court fee are not very high in Italy.
So you would perceive it as moderate compared to...
Yes, moderate. I would say moderate cost, yes.
Okay, and Germany, Felix?
In Germany, it works a bit like in Italy. We have the loser pays rule, so the losing party has to pay not only its own cost, but also the costs of the winner of the proceeding. Yet we also have this transparency, like in Italy. in contrast, for example, to the UK, where we have transparency about the adverse party costs because there's a statutory regime that determines those costs. The risk in Germany in private enforcement claims is even higher because usually you do not have just one defendant, but several defendants, or even if the plaintiff just issues proceedings against one of the cartelists, this cartelist usually gives notice to the other cartelist because of the joint and several liability of the cartelist, so the decision will be binding. In the past, a plaintiff, for example, which loses the case, had to pay all of those joining parties, or that was party cost of all of those joining parties, which could sum up to a very high amount. Recently, the German legislator saw this and changed the rules a bit. So even if you face, for example, 10 defendants, on the other side, the adverse party cost will be max 1.5 to 2 times compared to just one defendant.
Okay, well, that sounds, from a claimant perspective, reasonable. It's of course, if you start litigating against one defendant and you're suddenly confronted with 10, and you see the risks increased massively, I think that is a positive development. Thanks, Felix. We, of course, have seen the implementation of the damages directive. And one important feature of that directive is access to evidence. From a claimant perspective, that is, of course, important. Burden of proof for various aspects of the case is still on the plaintiff. In Italy, Giacomo, how is that arranged, access to evidence? And when you look at the damages directive...
Yes, okay, thank you for your question. So, generally speaking, we don't have procedural tools such as US-style pretrial discovery.
Mm-hmm.
That could be very important, but we don't have this type of, procedural tool. However, during the proceedings, you have the possibility to request for the disclosure of some documents that the counterparty has or a third party has.
Mm-hmm.
So the judge has the power to request the disclosure of this document, and this is part also of the damages decree, so that implement the European directive. And probably an interesting innovation is that there is the possibility for the court also to ask the discovery or the disclosure of the document that are in the file of the proceedings before the competition authority.
Yeah.
So probably this is the most important development in Italy regarding the disclosure of the evidence or the documents.
Yeah, in the Netherlands, situation is a bit the same, actually. That was already the case before the implementation of the directive. In the Netherlands, it's also possible to subpoena certain documents. Cannot be a fishing expedition, so the documents have to be specific. Interests of the various parties are weighed, and then the court takes a decision on that. So that's quite identical. For Germany, Felix, and by the way, there's no pretrial discovery in the Netherlands, just to be clear about that. Do you have that in Germany, Felix?
Indeed. So German law did not know any discovery regime before the transposition of the Cartel Damage Directive. But now the provision goes beyond the minimum standard set by the EU directive and allows for pre-trial discovery. So it is possible to only sue a cartelist to disclose certain kind of information without bringing a damage claim. The idea was that this mechanism will facilitate pre-litigation settlements, but this pre-trial discovery is applied very restrictively by German courts if they have no experience with the matter. In one case, the Lower Regional Court of Hanover ordered the defendant to produce the unredacted decision by the European Commission, but otherwise there have not been many positive court decisions yet.
Well, it seems that Germany is really making some movements in the direction of plaintiffs. This is a very interesting development. So, coming from basically no access to evidence, now something that is above the minimum harmonization. Very interesting and also very important for victims of cartels to be able to get the evidence that is otherwise impossible to obtain, because it's, of course, in possession of the defendants. That is an easy bridge, actually, to our next question. How would you perceive the general attitude of the courts? And maybe to combine this question with another question, how long does it take for proceedings to progress, for example, to mature to a settlement or a court decision? Would you consider that Germany is fast or moderate or maybe a bit slow? What's your view on that, Felix?
Maybe regarding your first question, it depends a bit what level of courts you look at.
Mm-hmm.
So the lower courts, I would say, are rather conservative, while the cartel panel of the Federal Court of Justice is almost progressive and in favor of the plaintiffs. With regards to timing, I think it's rather... it's definitely not the quickest, but also not the slowest jurisdictions. It will be somewhere in the middle. A first instance proceeding generally lasts between 3 and 5 years in complex antitrust cases, but we have also seen some exceptions where the first instance proceeding took 7 years or even longer. The second instance usually takes 2 to 4 years, I would say. And then if the case is accepted to the third instance, it will take probably around 3 years. All of that obviously there are exceptions, that's very generally speaking, but I think most of the cartel cases in Germany get settled in first or second instance, so it will usually not reach the third instance.
Yeah, I can kind of confirm the same timelines for the Netherlands. I think Dutch courts are rather progressive and pragmatic when it comes to these kind of claims. You can, for example, litigate in the Dutch language, in the English language. You can submit exhibits in those two languages, but also in German and in French, which is very helpful. For example, in the trucks litigation, we have a lot of Belgian clients with evidences in these languages, so that's very useful. Courts try to keep the pace moving forward quickly. They are well educated and trained and have a lot of experience with these cases in the Netherlands. So that's very helpful for the Netherlands when it comes to these kind of actions. Obviously, cartels are, for example, operating in the dark, and usually they are only discovered so and so many years after they occurred. And if you then as a plaintiff have to wait another 10 to 15 years to get your damages back, that's of course not very helpful. Italy, Giacomo, I'm curious about Italy. We sometimes hear that Italy is slow when it comes to litigation. But what's your view on these kind of cases?
Yes, basically the intention of the legislator was to increase the degree of specialization before the court of first instance. So in Italy we are 3 courts that have jurisdiction in the antitrust matter. That is Naples, Rome and Milan, and they are highly specialized. And in my opinion, this of course has an impact also on the duration, because they are very efficient, and also on the quality of the judgments. So answering to your question, I think that the approach probably is pragmatic. If I have to describe it, it will be pragmatic. And regarding the duration, it depends on, case by case, because of course there are 2 main aspects that can affect the duration of the proceedings. That is, the first one is how burdensome is the discovery phase, and if there is the need of the involvement of an expert for the calculation of the damages. So of course this could affect the duration of the proceedings. Generally speaking, in Italy, the duration of the proceeding before the court of the first instance is 3 years. But probably due to the fact that, as I said before, there are only 3 courts that are that have jurisdiction over the antitrust private enforcement proceedings. I think that the first instance could last less, like I don't know, 2 years. Probably, I think that it is 2 years the average duration of the private enforcement litigation before the court of first instance. In the second instance, it's around 2 years again, and before the Supreme Court could be 1 year.
Interesting. Yeah, that exclusive jurisdiction, I think that's a very elegant solution because indeed you allow the courts to become quickly more experienced on such cases. And I think it's smart that they choose 3 courts, not one exclusive court, because of course, if you get a lot of actions on this topic with one court, that experience might be helpful, but of course they will be overwhelmed by the amount of cases. So I think that's a very smart decision of your legislator to do that.
Yes.
Yeah. Good. Well, then maybe looking a little bit at the role of funders. We did already discuss the topic of adverse party costs. That's an obvious one. Funders can take away that risk for the plaintiffs because they provide no cure, no pay, but also no risk. So in some instances, funders can cover that risk. What is your view on making use of a funder in your jurisdiction, Felix? Is that something that's being done often? Is it perceived as useful? And in what ways?
It's done. It's generally done actually in Germany, especially in private enforcement claims, because the costs of a private enforcement claim are higher than other comparable claims. The reason for that is that you usually have an expert opinion from the plaintiff, an expert opinion from the defendant, and one expert opinion from the court. So that can easily double the budget for the lawyers. Therefore, it only makes sense to litigate by yourself if you have a very high claim amount. Otherwise, it makes sense to join a group to make use of the economies of scale, and these group actions are typically funded and managed by funders such as Deminor.
Yeah, and of course, besides doing it by yourself, having a big loss, you also must have the funds available to do it. But yeah, so it's mainly a way to structure claims collectively and have scales of economy, and a funder is well placed to organize that. That's how I understand it, right?
Yes.
I think that's the same for the Netherlands. Structuring of claims, also management of claims, assisting with obtaining the relevant evidence, transaction data that proves that you indeed were a victim to that cartel. I think also access to experts. You already mentioned it, Felix. Experts play a big role when it comes to causation and calculation of the losses. So indeed, having access to good local experts is key as well. Giacomo, funders, Italy, what is your view on that? Biggest advantages to work with them?
Yes, as you correctly said, probably the most important advantage in working with a litigation funder is that the companies have the possibility to optimize the legal cost. And of course, they can rely on the expertise of the litigation funder that can pay for a highly specialized lawyer, can have manage the claim, especially when we are talking about group actions. But I think that there is another obstacle that the victims of the cartel usually face in this particular litigation. There is the fact that they would have to sue their business partner. And so there is the high risk of jeopardizing the business relationship with this company. And so joining a group action initiated by a litigation funder can help in that sense, because the individual position of the company will be diluted in the group action. And on the other end, there is also the possibility, as you anticipated before, of sell the claim. So through the assignment model, because I think that the majority of the litigation funder offer the possibility of selling the claim, and in this case the company will have the possibility to monetize immediately, so obtain immediately a compensation without starting the litigation. And apart from the companies, I think that the litigation funding would be beneficial also for the lawyers, because again, even them can rely on the expertise of the litigation funder in the management of the group actions. And I would say also for the judges. Because if you think about Italy, all the tribunals are overwhelmed, and so for the judge probably it would be easier to handle one single proceedings instead of 100 proceedings with different individual claims. So I think that at the end of the day, litigation funding will be beneficial for the entire judicial system in Italy.
Good. Yeah, that's an interesting angle, of course, because suing your business partner or your supplier, that can be a bit difficult for plaintiffs, of course, and it could hold them back in becoming active on a case where they suffer the loss, obviously. So that's an interesting angle as well. And I think that is maybe a key conclusion anyway when overlooking these three jurisdictions. Yes, we have harmonization with the damages directive being implemented. But it's very clear that these three jurisdictions have some very interesting aspects, each to itself. Some common aspects and definitely some prospects of new developments maturing in the coming years. So I think these three jurisdictions, we will see a lot more litigation coming on these kind of cases. These were the topics that we wanted to address today. If you, as a viewer, would have any questions on these topics or other topics relating to these kind of actions, antitrust-related follow-on actions, please do not hesitate to reach out. We are happy to discuss any questions you might have. Thank you.
Thank you so much.
Thank you.
You listened to an episode of Antitrust Code by Concurrence. If you want to read more about this topic, check the Concurrence website where you can find all relevant articles. Follow us on Twitter @CompetitionLaws and join the Concurrence group on LinkedIn to receive updates on our next podcast.